It's comparatively commonplace to see women practising as barristers today, but before 1976 in New South Wales, it was a very different story. Ada Emily Evans holds the distinction of being Australia's first female law graduate. Coming from a family, as she put it, saturated in law, Ada Evans graduated from the University of Sydney's School of Law in 1902, just 1 year before her Victorian counterpart, Floss Greig.
At the time, the dean of the law school didn't want to admit women at all, and as I found in my own work, the dean was away on holidays and somebody else was an acting dean, and it was in that little narrow window that Ada managed to get admitted. By the time that he came back from holidays, Ada had been enrolled by the university, and it was too late to go back.
However, it was not until the Women's Legal Status Act was finally passed in 1918 that Ada was admitted to practice. Despite offers of briefs, poor health, family commitments and her long absence from the law combined to ensure that Ada Evans never practised. New South Wales' first practising woman barrister and beneficiary of Ada Evans' long struggle was Sybil Morrison, admitted to the Sydney Bar in 1924. Sybil read with Joseph Brown, a barrister and member of the New South Wales Parliament who specialised in commercial matters. As with so many of her contemporaries, Sybil Morrison proved a novelty in more ways than one.
She benefited from a male mentor in the first instance, and in her case it was the solicitor who at the time was Attorney General, and she really paid tribute to him. She said, "He has now shown that his concession to women then was not merely political, he has given definite proof of his faith in their ability." He was the one that I think made her admission possible by passing, what was it called, the Women's Legal Status Act. So, and he was Mr. D.R. Hall. But then, despite whatever difficulties she had in practice, she also praised her colleagues. And she's quoted as saying, "In the beginning, when I was terribly nervous, the men used to escort me along Phillip Street and into the court. There certainly is a prejudice against women in the law, but I must say that all the men were very good to me when I started."
Sybil Morrison worked with the National Council of Women in the 1920s, but contemporary newspapers were more interested in Sybil's femininity than her feminism.
Well, it begins with the Brisbane Daily Mail, who reported breathlessly that she was, quote, "stitching busily during the interview, which was evidence that her studies and profession had not supplanted her womanly attributes." And then it went on, "Like most women who've proved their utility and adaptabilities for spheres usually considered the monopoly of the male, this lady barrister retains her femininity in spite of the legal wig."
The second woman to practice at the New South Wales Bar was Nerida Cohen. She obtained degrees in arts and law at Sydney University and did her articles with Piggott, Stinson, McGregor and Palmer before going to the bar.
This was where I met my next snag. Everyone that I spoke to had some excuse. Either there were no facilities for women in the buildings, or they had somebody else. Something was always a good reason why they shouldn't take a woman. However, Mr. W.B. Simpson agreed to take me if he couldn't find somebody else who would. And that is how I started at the bar.
Nerida built up her practice, specialising in industrial and family law.
It was during the course of one of my cases before the Industrial Commission of New South Wales that I first put the proposition of gradual increase in women's wages. My proposition was that women's wages should be increased in the first year to 60% of the male wage, the next year to 65%, and by gradual increases of 5% each year until finally they achieved equality.
Nerida Cohen was interested in voting rights and divorce law, particularly in trying to get uniform divorce law throughout Australia. A keen feminist, Nerida eventually became Australian chairman of the Equal Civil and Political Rights Committee of the International Alliance of Women. Although she ceased to actively practice in 1946 when she married Bernard Goodman, Nerida Cohen became Vice President of the Liberal Party's Darlinghurst branch and eventually the first President of the Women Lawyers Association, founded in 1952.
When I came along, I permanently interrupted her career. She was a retired barrister when I was a child.
While Nerida Cohen was at the bar during the late 1930s, several women were admitted to practice but remained on the bar's non-practising list. Jean Mailer was admitted in 1937. Her brother Ronald was also a barrister. Jean never practised at the bar, instead becoming a highly respected editor at the Law Book Company and then Butterworth's for the rest of her career. Practising woman barrister number 3 was Anne Bernard, who before she came to the bar was a crack shot with a rifle, a keen aviator, and knew Sir Charles Kingsford Smith when she worked in Fiji in 1928. He called her Bernie.
That's correct. So she then decides to get a job at the chambers of Sir Henry Scott. And then she becomes like a law clerk in there. So I think that's the thing that motivated her to go and do her law at Oxford in England, 1938. So she went through the bombing of England. So just imagine the people she must have met. So she did 1938 to 42, comes back to Australia, apprised to the New South Wales Supreme Court to practice as a barrister.
In 1943, Anne Bernard was junior to Sir Garfield Barwick, then a King's Counsel, who unsuccessfully argued that the artist William Dobell should not have been awarded the Archibald Prize for his portrait of Joshua Smith, deemed to be a caricature. Throughout the 1940s, Anne Bernard ran a number of cases. She acted for the daughter of English suffragette Adela Pankhurst Walsh, who had been detained under wartime regulations, applying for a habeas corpus to secure her release. Anne Bernard then returned to Fiji to practice for some years, where she adopted a daughter, Angela.
I think she was a very outstanding woman. My father said to me, he said, could you imagine a woman in 1942 getting up in court and pleading? He said that'd be unheard of.
Practising woman barrister number 4 was Beatrice Bateman.
When she's in the law school, she marries and she's expecting my eldest brother, and the law school would not make arrangements for her to sit for exams because she was pregnant. And so in a certain amount of anger and disgust, she goes back to the Faculty of Arts and says, may I then enrol and do a Master of Arts? So that's how she graduated with a Master of Arts, pregnant and delivering the baby. It's an indictment of the law school that they were not prepared to accommodate a woman who was pregnant and due to give birth to a child at about the time of the exams. If you look at my mother's history of practice, you will discover that in the years that she is on the roll as a practising barrister, it lands between children. And it is almost the history of a woman who is married, raising a family. My mother saw that the women of the world really set the agenda for a family, and so her response to it was that if you educated a woman, you actually educated a family. And it wasn't so much whether she entered into a commercial career as a result. That was not her priority. Her priority was that that you would develop each of your children to the best of their ability. At the end of my mother's life, there is 2 years there that she is practising, and I was aware of the work that she was doing at that stage because I was slightly older. And so she's on the practising roll, 59 and 1960. She did a murder trial, and she also did litigation in relation to an insurance contract where the insurer refused to pay for loss of rental. And she litigated. She lost round one and she won in the Court of Appeal, and the judgment was published after she died. When she died, she was researching work for an Aboriginal woman charged with murder in the Northern Territory, and a Greek doctor in the Northern Territory had spoken to my mother because of the publicity over this other murder trial and asked my mother would she take up the cause. So I think my mother was doing work not for financial reward, for the intellectual stimulation and to assist.
In the late 40s, early 50s, several more women were admitted to practice, including Dorothy Shearer, Beck McPaul, Mary Appleby, Marie Kinsella and Zena Sachs. None of these women practised at the private bar. The late Joyce Shoecroft was admitted to the bar in 1942. She worked for the ABC as its media lawyer for over 30 years before practising at the bar in the late 1970s. Joyce has been described by her contemporaries as one of Australia's first media lawyers.
I would have had, over the years, maybe half a dozen cases against her. None of them were big. She always started off a matter as if it was a matter of principle and she was fighting for human rights. I wouldn't settle for anything other than the max. She always referred to my clients as Zat Alley Cat.
In May 1955, Elizabeth Evatt, daughter of eminent QC Clive Evatt and member of the well-known Evatt family, was next to sign the bar roll. Elizabeth Evatt won the University Medal for Law but was in active practice at the bar for only a few months before winning a scholarship to study at Harvard Law School.
In that very, very short time, I was ensconced in my father's chambers. That's the old Denman chambers in Phillip Street, where he had his practice. And because he was a very busy silk, practising in mainly personal injury cases, I got a few what they call noting briefs to sit with him and carry the books and write the notes. I appeared in the police magistrate's court once or twice. It was a negligent driving case. And I appeared before some public service tribunal for someone. Oh, and in the equity court, I had to go to a judge in chambers once to ask for an injunction. It's a very rare experience for a young lawyer.
And how were you treated by your colleagues at the bar during that short time?
Oh, there wasn't easy acceptance of women. There was definitely something a bit unusual. It didn't bother me all that much because I was only young. I was only 21, so because I was my father's daughter, I don't think I experienced anything very negative. Because most of the people knew Dad and they knew I was his daughter, so they accepted me in that light as much as anything else.
Next to practice at the New South Wales Bar was Kathleen Trevelyan, known as Kay or Kath. She had previously worked at the New South Wales Justice Department. An active supporter of other women at the New South Wales Bar was Janet Coombs, daughter of former Reserve Bank Governor Dr H.C. Nugget Coombs. Janet Coombs would take new women barristers to lunch in the bar common room to welcome them to the bar. The lunch held by the Women Barristers Forum and the Women Lawyers Association to welcome each new intake of women barristers to the bar is named in her honour.
I told Mum and Dad I want to be a barrister. Dad said, "What do you want to do that for?" So I said, "Well, Dad, you know I love talking. Imagine talking all day and being paid for it." The first 3 years I was at the bar, I was not allowed to attend the bench and bar dinner. The first year, I sort of only found out after it had happened, and I was terribly upset and wrote a very hostile letter, but I fortunately showed it to Godfrey Smith before sending it, and he tore it up and wrote another one, which had a tear in every line, which talked about how I had always admired their main speaker, how I had longed to hear him speak on this subject, how devastated I was at the loss of this wonderful opportunity, and how, if they would only let me come, women of the future would be so grateful forever. The next year I was not omitted from the mailing list like I had been the first time, but I got a letter telling me not to come.
Janet Coombs eventually purchased her room on the 13th floor of Selborne Chambers in 1969 and remained there for over 30 years.
Most of my work in my first 4 years was petty sessions, and I had been offered all this divorce work, which was a sort of slightly, well, much better paid and more prestigious, I would say, than the work I was actually doing. But I was happy. I was ecstatic to do even a mention in the Petty Sessions Court. I mean, I was so thrilled to be a barrister and so thrilled to be in court always. I never lost the thrill of it. It was always the greatest thrill of my life to stand up in court and do even a mention.
What was Helen's area of practice?
Oh, she was one of the divorce lawyers, and she was excellent.
When I first started here, Helen was a barrister on the floor. She was quite elderly at that time. I'd be guessing probably around 70 or maybe early 70s. Tiny little lady. And I seem to recall her field was like probate and wills, things like that.
I remember I went to one firm and they said, "Can you type?" And I said, "No." And they said, "Well, go and learn to type and you can come back as a secretary and then, you know, do some articles too." So I made a resolution that I would never learn to type, and I never did. came to Sydney to the bar in 1964 and stayed there till 1975 when I became a magistrate. Anna was a European background, which singled her out even more as having a European accent. People in 142 were sort of not outcast, but we were away from the main crowd in Wentworth and Selborne. My main memory of her is as being a quiet person who was dependable and conscientious.
So what was it like in those early years? What was the culture of the New South Wales bar like?
Well, I guess I'm a bit torn about that because the whole thing is, as I think about it, was really a sort of bittersweet experience in that there were some absolutely lovely men who were just wonderful and there were some who weren't. And then, of course, the problem was too that as a barrister you depended on getting work from solicitors. Now, you know, that was another difficulty, but a lot of men had problems getting work as well, so it's not as though... It's just that we had the extra problem, I suppose.
The extra problem being gender?
Yeah. But I didn't want to acknowledge that. And I have to admit, when they started the Women Lawyers Association, I refused to join and thought it was the wrong thing to do because, again, there was no Men Lawyers Association. And why should there be an association which excluded them and which was only women? I remember when they started, they moved the divorce courts down to 50 Phillip Street, which is now something else, I don't know. And when they were remodelling them, we had to go down in ordinary clothes and change there. And I saw it, and there was this robing room, one robing room and toilet. So I said to someone, "Oh, what am I supposed to do?" And they said, "Oh, well, you can go and change in the toilets." And I thought, well, this is not right, because at the time of robing, that's when you finally talk about settlements and all the rest of it, and I wasn't going to go in the toilet and change while all this was happening. So I thought, well, bugger that. I bought the brightest pink petticoat I could find and used to go down and strip down with the men, and at the beginning it was a bit strange, but after a while nobody really noticed, and I did my bit there as well.
The late Mary Cass practised mainly in equity.
She was a chain-smoking titan of fighter. She loved to fight. It didn't matter with who or whom. She loved to fight. We had chambers on the 15th floor, Wardell Chambers, which was a colourful floor at that time with lots of personalities. And she was one of the diverse personalities on that floor. She always seemed to get tough cases, or cases with difficulties, people who were usually on the wrong end of things.
Did she, by any chance, ever speak to you or to people you knew about how she felt it was like working as a woman at the bar?
Never said a word, and never. I think Mary would have taken exception to being called Miss, Mrs. or anything else. She was one of the boys and wanted to be one of the lads, yeah.
Cecily Backhouse, New South Wales' third woman to become Queen's Counsel or QC, came to the bar in 1964 after previously working as a solicitor.
The final solicitor that I ended up with was Cedric Simons. He had a very wide practice. It wasn't just a family law practice. But I did do, with him, I did do a lot of family law. there's no use saying otherwise.
I mean, I was told that women barristers in those days were mostly expected to do this.
Even my very good friend Bill Dean, when I was talking to him, about reading with him and so forth, Bill Dean, of all people, was to say, says, you might find that your practice will be mainly in family law.
Did you personally think it was a difficult or hostile atmosphere at the bar when you were there in those early years?
Talk it hostile, but I mean, I think, going back to what I said before, I think I knew a lot of the senior barristers and I don't think I had ever had any feeling of hostility or against me or the other women.
Cecily Backhouse was offered the presidency of the Administrative Appeals Tribunal, but instead opted to stay at the private bar where she took silk in 1987.
That was my greatest ambition, to be a silk.
During all those years in the lead up to your becoming silk, and we're talking a really good long number of years.
That's
right. Am I right? We're thinking almost 20 years in solid practice.
That's right, exactly. The men normally would have got it in, if they were really top class, they'd probably get it in about 8 years or something like that. Oh, yes.
Who have you got working with you there?
That's Peter Young. And he actually coached me in real property. So when I passed and I could be admitted, I asked him and he said certainly he'd love to. So he did. And then Peter Young went on to become the Chief Justice in the Equity Court later. Yeah.
So he was an important early figure for you?
He was very supportive.
Helen's Greek father, Mick Adams, opened Australia's first milk bar in the early 1930s in Martin Place, Sydney.
Well, I always wanted to study law, and then when it was time to go to university, my mother said, no, it's not fitting for a girl to go to university. All you have to do, get married and have children. She was very old-fashioned, very traditional. So I then did kindergarten training because I was allowed to do that, because that was a nice female sort of a thing to do. So I did that, and then I got married straight after, and then we started having a family. And before, I had one child, and I decided, look, I really still want to go to university, and I want to do law. So I studied by correspondence, and I got there.
How did you end up overcoming your mother's opposition to the fact that you were, I suppose you had your heart set on becoming a lawyer?
Yeah, well, I just had to, with my husband's support, because my mother actually tried to sabotage me by saying to my father, tell Jim that not to let Helen go to uni. She should be at home minding the children. It's wrong.
Helen Gerondis read with Ken Pawley and G. Barry Hall, and soon after was given her first brief in a trial known as the Murder for Kicks or Thrill Kill Gang Murder. Helen acted for the first accused's girlfriend.
She was living with McCafferty, and she was actually pregnant to him, and she was on trial because she was part of the gang, they said, and that she was involved in planning. But she didn't plan anything. She was just living with him. She just happened to be a bystander.
She won, and all the other accused were convicted, and Helen appeared on the front page of the papers. Mother of 6 wins murder trial, with a picture of her and the 6 children. I mean, you can't go much better than that, can you? Win your murder trial on your first case, and she did.
Before going to the bar, Jenny Blackman had been a shorthand typist, first for solicitors and then barristers.
I then was asked to work for someone I had worked for before, namely Mr Justice Ray Else Mitchell, and I went to work for him as his associate. Whilst I was working for the judge, I completed my bar exams and I was so relieved. I thought, I'll never do another exam. But I then got admitted on the 31st of May and the judge said that he was happy for me to go on working for him because of the skills that I had and the fact that we all got on well. And so I stayed there. Having passed all the exams, I then had time to look at what was going on, and I saw some people appearing in front of the judge, and I thought to myself, I think I can do as well as that, and in some cases I thought I could do better.
A senior counsel, A.B. Kerrigan, warned Jenny that the bar was no place for a woman, but nevertheless organised for her to do some research for him.
To begin with, I'd take anything, particularly if it had a brief fee on the back of it. But I didn't want to do divorce work, and when the new law came in, I just said, first of all, I was saying I'll only take divorce work for solicitors who brief me in other matters, and then eventually I said, I don't know anything about the new law. I can't take any work in the family court, and that's how I got out of divorce work altogether. But I was doing local government work, I was doing Crown land work, I was doing equity, resumption matters and things of that nature. And that specialisation came reasonably early in my practice through having been an associate to the judge in the Land and Valuation Court.
You would have been one of the very few, if not the only woman barrister specialising in those areas at that time?
Yes, I was.
Was it ever an issue for you at any stage that you might have someone who would not brief you because you were a woman?
Oh yes, there were people who wouldn't brief me because of a woman. In fact, I got admitted to the bar in Western Australia, thinking that I might get work over there. And I had someone who rang me and asked whether had seen the name J. Blackman as being someone who was admitted in Western Australia, and was speaking to me and said, I was wanting Mr. Blackman. I said, oh no, this is Miss Blackman.
In 1974, a room was purchased in Frederick Jordan Chambers, which was made available on a subsidised rent for a year to a woman beginning practice at the bar. The letting of the room was Jenny Blackman's responsibility, along with two other trustees, Janet Coombs and Priscilla Fleming. Jenny, in due course, was recognised for her services to women in the law with an Order of Australia.
Someone like Janet Coombs made it a feature of her career to assist newcomers. She was constantly wanting to increase the number of women at the bar, and she made an offer, which I was so grateful to accept in the end, that I could start my practice by sharing her chambers. But at the same time, there was another group of women who were here, who were practising, and they were of the age of my mother, and they would say things like, I hope you're not going to desert us the way your mother did and get married and go and have a family.
Beatrice ignored this advice and did have a family. It was harder to obtain chambers once she moved out from the room she shared with Janet Coombs.
I can remember one particular lead of the floor who is a senior QC who's still around and very well regarded. And he's going to remain nameless. When I went to see him, he said, Beatrice, I have no objection to you at all. I think you may have a wonderful practice. I think you'll have a wonderful career. But the problem is the floor really doesn't want women. If we allow one of you on, you'll insist on others coming, and we really don't want you. You just exchange work between each other, and you're a little club and you exclude us, and we don't see that that's to our commercial advantage.
What about there being a club?
Well, you wouldn't answer that to him, but the reality was they were and they weren't. Not all of them were. The reality is, in this day and age, that silk would never speak like that. But life was so free for him to speak like that, that was acceptable, and he thought it was fair, and that is how they spoke to you. I had won the prize in family law when I was going through, but I knew I didn't want to continue to do family law, and I felt that women were being slotted into family law all the time. The work that I really wanted and would love to have got, and I found that women couldn't get, it was government work, intellectually stimulating government work, and the men at the bar who had the right contacts could get it, but I found I couldn't get it.
Mary Gaudron, later to be the first woman judge on Australia's High Court, was admitted in 1968 after being the first part-time student to win the Sydney University Medal for Law.
Absolutely serious about going to the bar from the age of 8. Absolutely serious. I won't pretend I had all the money, but I had a sufficient amount of money and a husband who was prepared to guarantee me at the bank if I needed any more. I mean, I was doing it as a very sensible business proposition. I was shocked and outraged when I got there to find that the place was closed. I mean, absolutely closed.
You were the first woman on the Bar Council of New South Wales. Were those sorts of matters fresh in your mind during your time on the Bar Council?
Oh, yes, very much so. But let me say that there were some men who were aware of the problem, particularly Frank Hutley, also Trevor Martin, both of whom had been my lecturers and so on. And they were certainly aware that there were real issues. And I think those two proposed me for the Bar Council. And also, of course, it wasn't just the women's issue at that stage. It really was the closed, almost defensive nature of the bar. It was very inward-looking. It was very much about preserving things as they were.
Mary Gaudron was regarded as a fine advocate, earning the nickname Mary the Merciless. She had an extensive practice at the bar, with a special interest in industrial law and defamation, though she also undertook a number of civil rights cases. In 1972, Mary Gaudron appeared for the Whitlam Labor government in the Equal Pay case, which she successfully argued before the Arbitration and Conciliation Commission. There were two major equal pay cases, the 1969 Equal Pay case and the 1972 Equal Pay case. The 1972 Equal Pay case granted to women equal pay for work of equal value. However, some employers sought to avoid the application of the rulings by reclassifying or renaming women's jobs. In 1974, Mary Gaudron was appointed Deputy President of the Australian Conciliation and Arbitration Commission, from which she resigned in 1980. Mary was also Chairman of the Legal Services Commission from 1979 to 1980, and she lectured in industrial law and defamation at the University of New South Wales in 1980.
The role didn't have a wonderfully high profile. I know that the Attorney-General had approached other people who had turned the position down and turned it down or wanted other conditions. All jobs, you can make of them what you want. There were a lot of constitutional cases in the pipeline and coming along, a lot of it being what I would call the bread and butter of constitutional law, the Section 109 cases, for example. Similarly, you were having issues between the federal and state industrial regulations. So there was a lot of constitutional work bubbling along, and of course the native title cases were bubbling along at that stage too. So it was a very interesting time, and if you like to move into the constitutional area, it was wonderful. I rather think the bar wasn't smart enough to see what was happening or what was going to happen, so I don't think they were greatly fussed, as they might otherwise have been, when their golden boys had turned it down. They thought that the constitutional, all the good work, it would still be briefed out. Well, of course, it wasn't. That was there for the picking, and there you go. So I think after a while they got a bit concerned that the work was staying with me rather than going back to them. But anyway, that's c'est la vie.
Canadian-born Joan Palfreyman was admitted on February the 14th, 1969, followed by Jane Matthews on June the 6th, 1969.
My father said no daughter of mine is going to do law, and so I spent the next 2.5 years persuading my father in various ways that I should do law because, of course, he was going to have to pay for it. And at the end, he finally said, all right. He said, if you were a boy, I would have happily put you through both arts and law. As it is, the whole thing is going to be a complete waste of time. But if you insist you can do law, just straight law, but you'll undoubtedly go off and get married and it'll all be wasted afterwards. He was a bit embarrassed when I reminded him of that many years later after I'd gone on the bench. I had to make a decision very early in the piece, and did, to decline to do family law work. And it was really a choice between do family law or starvation. So I chose starvation. And it really was very difficult indeed for quite a number of periods. But I've sure never regretted it.
So how did you keep body and soul together?
I ended up doing quite a lot of legal aid work. That was the one field where as a woman you could get it. And through this ended up doing criminal trials, quite a lot of criminal work. And that was a really positive thing. That set the direction really for a lot of the rest of my career. The magistrates were sometimes pretty dismissive. Other barristers, by and large, once they got to know me, they were fine. I had some problems in the earlier days with a few of them who just didn't want women around.
A bit like Monty Python, are there any women here?
Something like that, yeah. I had a very amusing experience. The very first time I appeared in the Court of Criminal Appeal, it was presided over by the Chief Justice of the day. And it may be that it was, I don't know whether I was the first woman to appear before the court. It's unlikely, although remotely possible. Anyway, I had an unlosable case. It was a severity appeal, and through some quirk, you only realised it when you went behind and did calculations. The sentencing judge had actually sentenced my client to more than the statutory maximum. So I had to win. And I got to my feet, and the Chief Justice took over, and he said, well, Miss Matthews, you'd say, argue such and such, and from that you'd... So he presented to me the whole of my case, and I just stood there saying, yes, Your Honour, yes, Your Honour. At the end of it, and I swear this is true, he sort of turned around and discussed things with his with his colleagues, and then he turned to me and he said, well, Miss Matthews, your eloquence has persuaded us, and he proceeded to find in favour of his own arguments.
Jane Matthews went on to be the first woman appointed to full judicial office in New South Wales. She served as District Court Judge between 1980 and 1987 before being appointed to the Supreme Court of New South Wales. With no female colleagues on the District Court, she also spent the best part of 7 years as the state's only female Supreme Court Judge. She was appointed a Federal Court Judge in 1994 and served on that court until 2001, and was President of the Administrative Appeals Tribunal between 1994 and 1999.
everything was just beginning to turn around. Everybody was talking women's rights, equal pay, all that sort of thing. So, and I became very involved in that, giving speeches and doing things all the time. So that is probably the only reason that there are photographs of me, because the Courier Mail used to follow me around. You know, there was one very early in the piece I can remember, appearing in the Magistrates' Court. Graham Bell, who was a few years senior to me and became a family law judge later, Graham appeared against me and told me the story that he said, "Oh, I walked in there and I saw you and I thought, oh, this pretty little thing." And then he said, "You opened your mouth, you bitch."
Nada Haxton moved to Sydney with her family and was admitted to the New South Wales Bar in 1971.
I'm round in Frederick Jordan Chambers, and Nada Haxton has come down from Queensland, and those black robes are very forgiving, and I'm very pregnant. And Nada said to me, "When are you going to tell me something?" And I said, "Oh." And she said, "When are you going to tell me you're pregnant?" And I said, "Well, I wasn't proposing to." I said, "No one has noticed." She said, "Well, I've noticed." And she said, "Haven't you noticed me?"
Nada Haxton did devilling work for various counsel, and during her years of practice, an increasing amount of lecturing, law reporting and editing.
Somewhere in that period, I also was asked to edit the local government reports for all states except New South Wales, so that was for the whole of Australia. And I think that was in recognition of the fact that I knew a broader range of law than most people probably did. And by that stage, I'd become totally enamoured of law reporting, loved what I was doing, and had become quite involved with not only law reporting and the Consultative Council of Australian Law Reporting Bodies, but which started in 1983, but with judgment writing and being asked to go and talk to the judges on occasions.
Did you aspire to being a silk?
I applied 3 times and was always knocked back, although I had assurances from people that they would support it and see it through. And I know that the Court of Appeal judges fully supported it, but because I wasn't running around in being seen in court, it's not on the bar agenda here, and I noticed it doesn't appear to be. The editors of the English law reports are accredited with silk because they're editors of law reports. Yes, it's something that the profession here might like to take a look at.
The first New South Wales woman in private practice to be made QC was Priscilla Fleming.
When I left school, I did an arts degree at Sydney University and then got married at 21, had 2 children in quick succession, and then just needed something to exercise my brain, and some friends, legal friends who were lecturing at the BAB course suggested that I might like to do that course.
The BAB course being, of course, the Barristers Admission Board.
That's right. And so at first it was just for the mental exercise, and I went through that. Because I had a degree, I could do that a little bit shorter. And when I came out the end of that, I said to my father, well, I think I'd like to go to the bar, thinking I'd get all sorts of encouragement from him. And instead he said, "Oh, no, Priscilla, no, the bar, the rough and tumble of the bar is no place for a woman." And despite that, I decided to go to the bar, and of course when I did get there and proved to be reasonably competent, he was very, very proud of me. I managed to get some criminal briefs. That was for the prosecution. That was another advantage of my father being so well known and respected. The Commonwealth Crown Solicitor was very good to me. I did work for the State Crown Solicitor. I did prosecution and defence in criminal law. The administrative law came a bit later, I think. I suppose when you've got more experience, the statutory interpretation needs a bit more experience, and that came in the later years. I was counsel assisting in the Juanita Nielsen inquest. She was a lady in King's Cross who'd been fighting against developers, and she disappeared and presumed dead. And it involved some really shady characters from King's Cross underworld. And I was cross-examining one of them. He was known as a colourful King's Cross underworld identity. And he was in the witness box, and I was examining him. And all of a sudden he dived to the floor and disappeared from view. It turned out that he had been in partnership with another of these colourful characters, but now was an enemy of this colourful character. And he dived to the floor because he'd noticed what turned out to be a window cleaner at the skylight in the roof of the court, and thought that the window cleaner was an assassin come to shoot him in the witness box. There was a tradition as you went into lunch, say in the bar common room, you would take a seat to fill up a table that was already filling. You wouldn't go and start a new table. You had to go and fill up, say there were 4 seats taken and 2 left, well, you'd go and take one of them. And the hostility was palpable. People just didn't want you to come and sit at their table, but of course you had to. And then, as they got to know you, that got better and better. But I always felt that there was still some residual hostility, even in my final days at the bar.
The late Pat Moore was admitted to practice on the same day as Priscilla Fleming, with whom she was already good friends.
She was a pharmacist. I think she'd got honours in her pharmacy course. She was a very, very bright person. And when she came to the bar, the pharmacy background was a great help. She did a lot of patent work involving a lot of chemistry.
She also, I believe, later on became a senior member of the Administrative Appeals Tribunal.
She did, and I think they did patent appeals too, so she would have been very useful there.
I was working for a firm called Curry & Curry, and I was doing very boring work. I was working as a law clerk after I was admitted to the bar. And one day this man came in, and his name was Mr. Nurse, and he said, "I'm sorry, but my wife can't come to sign the documents today. She's in court. She's a barrister. But I'll make another appointment for her." And I said, "That's very interesting. I'm a barrister too, but I'm working as a law clerk." And he said, "I'll tell my wife and she'll give you a ring." So she did. So she invited me to come up to her chambers, and she had there on that day about 3 or 4 other barristers. I can remember there was Janet Coombs, Priscilla Fleming and Jenny Blackman.
And would I be right in guessing that the woman barrister who had invited her to her chambers was Mary Gaudron?
It was Mary Gaudron, yes. Jenny Blackman took me to her bank that did a lot of banking for barristers, and they lent me, I think it was $6,000 at that time. And Jenny Blackman went around and found a wig for me and robes and everything that I needed. So in February 1973, that's how I started out in practice.
Carmel Marlowe's practice included family law, equity and government work.
In my early years, I did a lot of trials. I did a big drug trial that went for 8 days, and I was very, very junior at the time, and all the other barristers who were experienced criminal barristers, their clients ultimately pleaded guilty, and I was left on my own because my client wouldn't plead guilty. I was left on my own to run that case when I'd probably only been in practice for about 12 months. And there was another case that I was extremely nervous, but after 8 days, I eventually won that case. I found at the bar people were extremely courteous, and even though I was a female, the judges always treated me with respect, and the barristers treated me with respect, and it was a very dignified profession. I couldn't see any negatives apart from the fact that it was difficult getting briefs. It was also difficult getting difficult briefs, particularly with the governments, that would sort of advance your knowledge and experience. Most of my briefs I got from the private industry rather than governments. The Commonwealth Legal Aid Commission always gave me a lot of work. As far as being a female, I do think that the area that I practiced in, there seemed to be more female barristers. I think that we made a very positive inroads into making things easier for female barristers to come to the bar.
I was in court one day before a very crusty old family law judge, and in those days they were still doing the very old petitions. It was 1975, it was before the Family Law Act was introduced, and so the judges, the Family Law Division was still part of the Supreme Court. And I was in court running through one of these petitions, and I came out. A gentleman as equally crusty as the judge tapped me on the shoulder and he says, "Oh, excuse me," he says, "I've just worked out who you are." In that very crusty old voice. "You must come up and meet the other members of the floor." And at this stage, I still actually didn't even know who he was. It was Peter Vine Hall, a barrister on the 9th floor. And he said to me, "Haven't seen one of you young ones not fluff your lines." And he went back to the floor and he spoke on my behalf. And I'm told that that's why I got the room.
As with many of her women predecessors at the bar, Margaret Beasley was compelled to take family law work to begin with, which brought her before Justice Anthony Larkins.
I was in court one morning getting ready, and Larkins' associate was also in court getting ready. And I'd actually always thought she was a bit difficult. She just said to me, "Oh, Miss Beasley," she said, "oh, good to see you." She said, "I really enjoy when you're up here." She said, "I've never seen anybody stand up to him as well as you do." And I thought, I see. That really changed my mind, because I thought, no matter how difficult it is, and I can't tell you what an excruciating experience it was to have to appear before him, I did find my way, and I know how I found my way around dealing with him. What I notice is that if you let him carry on, and he had a wonderful command of the English language, and he would spout forth on these in this extraordinary way, and I'd just let him do it, and I'd just wait for him to pause, and I'd move on to my next submission or my next paragraph. And so in a way I'd let him not implode, but getting along that way.
You let him sink himself.
Exactly. And he'd have no more to say, and I'd get through to the end of it. I'd get my orders, and that's all I was there for at the end of the day.
From 1976, the numbers of women in active practice at the bar increased somewhat, a point that didn't go unnoticed by the media.
One of the real problems, and it remains a problem to this day, is that too few women are going to the bar. Even then, back in the 80s, women were starting to go through law school in pretty much equal numbers. And certainly for the last 20 plus years, women have been graduating in more than equal numbers from the law school. We've still only got something, I think it's 17% of women at the New South Wales bar. And that's terrible. And the problem here is that by and large, the bar still constitutes the pool from which judges are appointed. And so with only 17%, we don't have enough in the pool.
What to you are the systemic barriers that remain to women rising up in the profession and being accepted to the point where we could all just say we are all barristers? We are not women barristers or men barristers, we are all barristers, for example.
Work hours. I would put it down significantly to work hours. When I was appointed, I'd only been a silk for 3 years, and I was becoming unbelievably busy. And I had 3 young kids, quite young. The youngest was 15 months when I was appointed to the bench. It gave me a structure, which I didn't have otherwise. And the structure was actually the amount of leave that I had. If you're going to have family, you have to have a lot of help.
How far have we still to go?
Look, the main issue hasn't changed. It will never be easy because the barrister's life is very demanding. And if you're engaged with clients, you don't have control over, not complete control over when a case comes up, when you're required. You've got to be there. You've got to be available. And if you're not available, that will go against you career-wise.
Oh, I think if you want to go to the bar, you have to go to the bar, because if you don't, you'll wish you did. And whether it's easier now than it was then, I don't know. In some respects, maybe yes, in others, no. It's an individual choice, but I think it's a good life.
People told me don't come to the bar, and I came. If you want to do it, you do it. And if you fail, you fail. And if you succeed, you succeed. It's everything in life you have to make your own decisions about, and you can't rely on somebody else to tell you what to do.
Go for it. I mean, absolutely. One thing I do say, though, is if you don't love it, don't do it. I think the bar is too hard as a profession for anybody if you don't really love it.
The position of women has improved by the higher profile of women in the profession. I mean, you've got 3 Sheilas on the High Court now. I mean, that's got to improve the profile of women generally.
So what advice would you give to women thinking of coming to the bar today?
Please do it. We need to get the numbers there.
I'm sure that anyone that's ambitious and wants a good life, I think the bar is a place to go.
And women who are actually at the bar at this moment, what would you say to them?
Congratulations, stick to it, yeah.